The 14th Amendment contains rights in addition to those rights enjoyed by Americans in the Bill of Rights. We're going to be talking about due process and equal protection under the law. Those are the rights that the 14th Amendment adds to the Bill of Rights. The 14th Amendment was part of 3 amendments that were added to the Constitution after the Civil War ended in 1865. They included, in addition to the 14th Amendment, the 13th Amendment, which outlawed slavery, and the 15th Amendment, which expanded voting rights to male ex-slaves. We'll discuss the 13th and 15th Amendments later in the course, probably in May. The subject today is the 14th Amendment. The 14th Amendment was passed to enshrine in the Constitution a statute, a law, passed by Congress in 1866 that guaranteed civil rights to ex-slaves. That law was called the Civil Rights Act of 1866, and Congress wanted to make that law permanent by putting it in the Constitution as the 14th Amendment. It placed 3 limitations on state power. First, states could not limit the privileges and immunities of United States citizens. Second, states could not deprive any person of life, liberty, or property without due process of law. And third, states could not deny any person equal protection of the laws. Essentially, these limitations mean that states could not treat ex-slaves differently than white people. That if a white person could marry, so could an ex-slave. If a white person could own a gun, so could an ex-slave. Specifically, the 14th Amendment's first part, the part that says cannot eliminate the privileges and immunities, protects the rights of national citizenship, such as access to courts, the right to travel, the right to vote in national elections, and the right to engage in interstate commerce. States cannot pass laws abridging the privileges and immunities of United States citizens. Let's take a look at the second limitation on states, the Due Process Clause. This clause is identical to the Fifth Amendment's Due Process Clause. The Fifth Amendment's Due Process Clause applies to the federal government. The 14th Amendment Due Process Clause applies to the states. The most significant effects of the Due Process Clause is its application of the Bill of Rights to the states, and it protects rights not specifically mentioned in the Constitution. For example, a right to education, a right to travel, and a right to privacy. The Due Process Clause answers the question, is the content of the law fair? I probably should have put this in here. Here we go. So is the content of the law fair? So ask yourself, is a law fair that says black kids can go to this school and white kids can go to that school? Is the law fair that says people who make over $100,000 a year must pay 4% of their income in taxes, but people who make less than $100,000 per year need pay only 20% of their income in taxes? In addition, states cannot pass laws that limit your fundamental rights, those rights that exist in the Bill of Rights, such as freedom of speech, freedom to exercise your religion, and the criminal and civil procedures that must be followed before you can lose your life, liberty, or property. Okay, now, let's get to the meat of this lecture here, the Equal Protection Clause. As the slide says here, unreasonable discrimination. I'm sorry, as the clause prohibits unreasonable discrimination. If the law treats people differently, there better be a good reason. Now, all laws discriminate. For example, you cannot get a driver's license until you are 16. So the law discriminates against 14-year-olds who know how to drive. However, there are varying standards of legality depending on who the law affects and why the government passed the law. Most of the time, if the government can prove that there is a rational basis for the law, that there is a legitimate government purpose, the courts defer to the legislature and the law stands, like the driver's license law, for example. So, laws that discriminate, though, unreasonable discrimination, is usually discrimination on the basis of race, gender, religion, national origin, and other classifications such as sexual orientation or disabilities. What then is unreasonable discrimination and therefore a violation of the Equal Protection Clause of the 14th Amendment? Laws that discriminate based on race or national origin are held to the highest level of judicial scrutiny. The standard is called strict scrutiny, and for such laws to not violate the Equal Protection Clause, there must be a compelling government purpose for the passage of such laws. In addition, if a fundamental right is the subject of a law, such as a right to trial by a jury of your peers, and a statute is written that excludes black people from juries in which a black person is a defendant, that law must also pass the strict scrutiny standard. Is there a compelling government purpose to exclude black people from juries? Well, typically the answer is no. The strict scrutiny standard was first articulated in the Korematsu case in 1944 involving Japanese relocation during World War II. You remember that when we were talking about Franklin Roosevelt and his executive order. In that case, only Japanese people living on the West Coast were subject to removal to detention camps, even though German people and Italian people also lived on the West Coast. In this case, the Supreme Court found a compelling government purpose in the wartime emergency. So far, the only valid compelling purpose in laws that discriminate on the basis of race is national emergency, such as was the case after Pearl Harbor. In the famous 1954 case of Brown versus Board of Education, involving discrimination in the assignment of schools, the Supreme Court found no compelling government purpose in assigning children to elementary schools based on race. So, any law that discriminates or punishes on the basis of race is likely to crash and burn because there is no compelling government interest in passing the law. Racial animosity will not be protected by the court. However, what about beneficial laws that discriminate on the basis of race? These laws involve affirmative action, attempts by the government to give advantages to black people on the basis that African Americans' race has suffered from the effects of slavery and decades of racial discrimination. When white people or other people have brought suit against such laws for violating the Equal Protection Clause, the courts have found that race cannot be the factor in granting a benefit, like entrance to a university. Rather, race can be a factor among many. Why? Because the government has a compelling government interest in the goal of diversity. No other purpose to date has been accepted by the Supreme Court as compelling. Remedying past discrimination, not compelling. Providing role models, not compelling. Enhancing services provided to minority communities, not compelling. They've all been rejected by the court as justification for laws that confer a benefit based on race. Let's go down here to the second level. Laws that discriminate on the basis of sex also violate the Equal Protection Clause, but the standards of review are somewhat between rational basis and strict scrutiny. It is called, oddly enough, intermediate scrutiny. Under intermediate scrutiny, gender discrimination will be permitted only if the government can demonstrate an important government objective. Cases in which the government was unable to demonstrate an important government objective include an all-girls nursing school, which a boy wanted to enter, so he got to go in. An all-male military school, which a girl wanted to enter, and she got admitted. Laws that permit women to buy beer at 18 years of age but prohibit beer sales to men until they reach 21 was also found to be discriminatory, but in this case against men. So what the state of Colorado did was they raised all the sales to 21. This area of the law is in flux. Justice Ruth Bader Ginsburg, in her opinion involving the military school that I just told you about, announced a new standard for gender discrimination. She said exceedingly persuasive justification. But she was the only one on the court who stated that rule. Nobody else agreed with her. So her standard is not yet the law. Laws that discriminate on the basis of other characteristics like religion, disability, age, poverty, sexual orientation are subject to some kind of scrutiny between rational basis and strict. Generally, when the court strikes down such laws, it does so using the rational basis standard because they say there is no legitimate government purpose for these classifications, for these types of laws. An example of this is a law that the Supreme Court struck down in Colorado that prohibited the legislature from passing any laws that benefited or protected people on the basis of sexual orientation. The Supreme Court said there's no legitimate reason for that. Now, you might ask yourself, what's the difference between legitimate, important, and compelling? And the answer is, that's why lawyers make a lot of money. Here's the example that I'd like you to work through. It's on your worksheet. It's the first one under situations. I was telling you about the military case. You sort of already know the answer to this one, but go ahead and work through it. And then when you're done with this, I want you to complete situations 1, 2, and 3 from the 14th Amendment Equal Protection Under the Law worksheet. And then once you have completed 1, 2, and 3, if you feel inclined to continue your education, you might want to take a look at the next slide, which talks about a situation that I made up involving the Los Altos High School field hockey team. And a boy wanting to join the girls' field hockey team. So you can take a look at that and try to go through the analysis. Is this a strict scrutiny, intermediate scrutiny, or is there a rational basis for the law? Have some more examples here. If you go back to situation 2, involving the man named Bill who wanted to join the fire department because he was too short, got denied because he was too short. What if we changed too short to any of these other factors? Because he was black, because it was a female, because he was gay, because he was French, because he was one-armed, because he was unable to lift 250 pounds, because he's 41 years old, because he's unable to do algebra, because he's Mormon, because he's an ex-convict. You analyze these things the same way. Do you do it on the basis of rational basis, intermediate or rational scrutiny, intermediate scrutiny, or strict scrutiny? Have fun with it. Thanks for listening.